Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today, the focus of the show is real estate. Real estate has come off the bottom of the ground. Market values are starting to increase a little bit. Listings are very short now. If you're in the right area, houses are selling. And we happen to have my co-host, Jesse Barrientos, who just happens to know quite a bit about real estate and handles real estate closings for the past 25 years. Jesse, welcome to the show.
Thanks, Dave. Nice to be here again.
Good to see you. Let's dive right in.
You as well. Well, I know we've done a few of these before, and it's really nice during this time because the spring is the time to purchase real estate, to look for real estate. There's a lot of, I still think that it is a buyer's market. There's still a lot of the foreclosed properties and things that are out there. So, you might be able to snag a real kind of a deal. Now, when people get a realtor, and I don't suppose you don't necessarily need one, but it's good to have one because especially if you're buying, they know what the listings are, they know what you're looking for, and they kind of help you in whatever area you're at, and presumably they're familiar with that area and the market wherever it may be. And so once you find something that you decide that, hey, listen, this is the property that I want, we want to buy it, we want to make an offer, and then you go from there. Then the realtor will fill out a contract with you and for you. And basically what that is, we have a copy of this. It's a multi-board residential real estate contract. I think they're up to like 5.0E or something now. And basically what that is it stratified all the real estate contracts. So there's basic boilerplate language and everything else, and there are certain things that you check off depending upon your transaction. Obviously, one of the things, once you find the property that you want, is to, and you're doing the real estate contract to make the bid on it, or the offer, is obviously the identification of the parties and their names and everything else. And the realtor will help you fill that out. You also want to be careful and look at it. There is a section in here for fixtures and personal property. You want to make sure that, hey, listen, if this Viking oven and refrigerator is part of the list and everything else, that's the one that you get. And so there's a place to check it off on. If it's something like a Viking or something of that kind of nature, you want to make very sure that the description is written on there just so that there's no issues, because sometimes...
But even things like ceiling fans, built-in cabinetry, you want to make sure all that is listed here so that you're actually getting what you are seeing, or if you're not getting it, that has to be disclosed by the seller that we're taking this particular item with. Maybe there's a chandelier that's, an heirloom or something that they're going to take with. As long as you know it and it's disclosed, you have a meeting of the minds.
Exactly. And, it even has on here for vegetation and stuff like that. And, I'd hate to think that somebody would, dig something up, but you just want to make sure, because there's been a lot of transactions where people go in and it's not necessarily that the appliances are gone, it's that they're not the same appliances that were there when they looked on the contract.
It's funny you mentioned fixtures, but I think the most important item to most people is going to be line 35, which is the purchased price. And that's important because once that's agreed upon, that can't change.
Well,
except by agreement.
Right,
except
exactly.
By a reformation of the agreement.
By agreement, that's true. So when you do the purchase price, and again, then you want to make sure, and your realtor would be able to help you out. Now you want to make sure that your realtor, probably isn't a double agent. And what that means is that he's representing, and he has to make a disclosure, she has to make a disclosure, representing both the seller and you, the buyer. And if that's the case, you might want to be a little more circumspect, a little more careful about that, because realtors get paid from the commission, and again, you just want to make sure. That's why you also want to get a good attorney who does real estate and can protect your interests. So that's one thing you want to watch out for. But you fill in the purchase price, and your realtor is going to be able to tell you how long it's been listed, if there were any other kind of offers that they're aware of because they know the property, or maybe know the other realtor, those kind of things. What did it last sell for, and all those. So when you put the purchase price in, and then also you need to check whether or not it's going to be a cash deal or whether or not you're going to get financing. That's very important.
Yeah, most people are in need of financing.
That's true.
And the rates are historically low right now. So for that, you need either a mortgage broker or a bank that you're working with.
And my suggestion would be that you go to the bank that you've done business with. You go to them first and see what you could do. Actually, what I would do even before you sign a contract is go to try to get pre-approval to your bank and kind of figure out what the limits of your budget is. And then once you do that, they could give you a pre-approval letter, and what that will do is it'll make you more appealing to the potential seller, because the seller's going to want a cash deal, because they don't have to worry about financing that might fall through. Okay, all right, but then now we have somebody who has a pre-approval and somebody who doesn't. So between the two, who do you think the seller is going to favor?
The pre-approval.
Exactly right.
They want the deal to go through.
Exactly.
To completion.
To completion, and then
Not just an offer that sounds good with no teeth behind it.
right, they want, and a lot of times, sometimes they might be in a real bind because they might be selling this and purchasing a separate house, and so there's a balancing act that they have to do in order to make it happen. Because if my sale here to you is going to be affected and that's going to fall through, then my purchase of the other property, there's going to be a problem with that too. So that's why you have to it's a fine balancing act, and that's why you need a good attorney who does real estate.
Okay. Let's talk about earnest money,
Yep.
because it kind of goes hand in hand with purchase price. You have to show that you are earnest in your offer, right?
correct.
Is that what it's for? Good faith. Good faith.
That's right.
What's a typical earnest deposit on a piece of property that's worth $200,000?
$200,000 could be anywhere between $3,000 to $5,000. Again, like you said, it depends on how serious you are. If you want to send a message that you're serious, then the earnest money can certainly be increased. But I wouldn't jump the gun so much on that. I would follow your realtor's advice. The earnest money, and we'll talk about that as we progress through the contract, will be set off against the purchase price. When you do your closing, there'll be like a balance statement. It's called a HUD-1 or a RESPA, and it will show exactly where all the money and all the expenditures are and give you credit for those type of things. And we'll get to some other things until you get the probations that are coming down here in the contract. But so you just want to make absolutely certain that all those are taken care of. And then you have your closing.
The date.
Right. And that can be changed, and very often they do get changed. You want to have it close to that as you can, but again, a lot of times that gets pushed. Either it could be pushed back if everything's taken care of, or it could be pushed further down the line if you haven't procured your financing. Because if it's not a cash deal and you have financing, then your contract is contingent upon you securing financing. But you have to let them know. And there's notice provisions in here. We're not going to get too specific, just general, so that everybody at home knows what the process is.
We
and
want to help
everything else.
people purchase a house, not discourage them from
Exactly
purchasing a
right.
house.
Well, but hey, it's something you want to pay attention to. The other thing is possession. Generally, what happens at the closing is the buyer takes possession. When, Dave?
At closing.
At closing, when the closing's done.
Hand me the keys, the garage door opener, all the warranties,
Exactly right. Now, sometimes
and tell your story walking.
exactly. Sometimes what will happen is, because of what I told you about somebody maybe purchasing another house, and so the sellers might want to stay there for I don't know, a couple weeks or a month even after the closing.
They're going to pay a price for that.
And they're going to pay a price for that. There's going to be a holdback from the sale that's going to go into escrow to ensure that it's going to be delivered to them in the same condition as at the time of the closing. At the time of the closing, your realtor will take you through and you'll do another walkthrough to make sure everything is as it should be and as it was. And they'll also pay rent in whatever amount that you agree. And that's a document that your attorney can help you with in terms of securing that agreement and that stuff as well.
This is only on the rare occasion that somebody cannot vacate by the date of closing, correct?
That's true, but it does happen, just so that people can be more aware that it might be good for them, because they might actually get a positive cash flow for that little period of time. Who knows? And then there are disclosures, and I made some copies of these, Dave. They're very well. Let's look at the first one, and I know this is something that you know a lot about, Dave. Let me ask you about it. It's the Residential Real Estate Property Report Disclosure. So You tell me, Dave, what do you have to disclose on there?
Well, basically, if there's water damage, if there's been flooding, if there's something structurally wrong, you have to make the buyer aware of it. And as long as they're aware of it and they accept it,
Right.
then you're
Material
okay. But if you
defects,
hide it,
right?
if you lead them to believe that there's never been a problem in the last year and that there is no issue, and then there obviously is an issue, you're putting yourself on the hook for being a defendant in a lawsuit.
Well, what happens, Dave, if I've repaired the problem? Yeah, I did have leakage, but you know what? I had one of those outfits come over and dig around my house, and they fixed the problem. And since that time, I've had nothing.
Well, as long as you disclose that fact and the
Well, I don't
buyer's
think
aware of it,
I'm not sure that you have to disclose it, but the better course of valor is what?
discretion.
Is to make that disclosure,
Right.
so that there's going to be no issues whatsoever. And then, and again, you have to sign that as well, and that's for the seller, but also the buyer wants to be aware and wants to look at that. Then you also have the mold disclosure report. You know, a lot of houses, that has been a more of an issue. I don't want to say lately, but certainly within the last several years. Mold can be very hazardous, not only to your health, but also if you have small children and everything else that could count for allergies. There's been situations where people have bought a house and they've been sick. It's a sick house, and realistically, and so you want to know about the mold.
Okay.
How do you get
know
mold,
as a
Dave?
seller?
Was that?
How do you know as a seller
Right.
whether you have mold in your house?
Well, here, it's sort of like one of those things like, here's your sign. If you had water in the basement and you didn't take out the drywall, okay, you might have some mold, right?
Right.
If you see black spots developing, in the black is what? Is the mold, right? Then you probably have mold.
Okay. If there's no water damage, nothing in the basement,
Well, but here,
nothing in the roof, then are you pretty much
Right.
safe on that disclosure?
You should be, but here's the thing. A lot of times, you see those vents in the bathroom, right, that go up the ceiling fan? Okay. Now, the proper way to do that is to vent it completely out through the roof and out. A lot of people, or a lot of houses sometimes, guess what? It gets vented into the attic, into the crawl space. And you know what goes up there, Dave, when you turn on your ceiling fan after you've taken that nice warm shower?
Mold, water.
Water, which can lead to mold. Now, it's true that the homeowner might not know that. Now, the only other way he would know is obviously if he's had some kind of an inspection and had some mold abatement, and that goes to the other disclosure as well. So you have that, and that's nothing. That's something you need to look at. Also, radon, radioactive gas that can come up. Well, I know. We don't want to. We just want to make sure everybody. There's a lot of stuff,
A lot
right?
of stuff here.
And there's disclosure too. There's testing that you can do, and obviously the buyer,
little hockey puck.
the little hockey, exactly right. The buyer can request that. And you know what? If you're making this big an investment, $100 or two in doing these type of things, you know what? I think it's certainly well worth your money. All right. So you talk about that, and then you talk about the lead-based paint disclosure, and that's only for stuff really before 1975. That's when, a lot of paint before then, really did have lead, and
It was leaded.
yeah, and the little children, infants playing, they put everything in their mouth,
Right.
and so that can be very, very hazardous. So you also want to know, not only have the disclosure, but also, hey, have an idea when that place was built, and then they give you a booklet protecting your home from lead, and looking at all different kinds of things. So you should get that stuff from the realtor. He would have those things, and that's part of the contract, really, in terms of signing that.
And hopefully the seller, again, is being honest with these disclosures and giving
Correct.
you an opportunity to really see what you're getting.
Right.
Because a lot of it you don't know until you've had an inspection.
Right.
And that's after there's a contract accepted.
Yeah. And then
For the
you
most
might
part.
be able to get out of that, and we'll go through that and we're almost there with the attorney review. But so we talk about that, and now we'll talk about the prorations. That really applies to a bunch of different things. We're talking about if you're buying a place and there is a renter in there, it probably won't apply to most people who are buying the first time home, right? Because they're buying the home for what, Dave? Because they want to live there. But for taxes are paid in arrears, and what that means is that the taxes that you're paying now that are coming up here, right, are for last year. And like all good things, or maybe not so good things, do taxes ever go down, Dave?
Haven't seen it. I'm waiting for that to happen.
Yeah, maybe in your time or my time or somebody else's time they will, just like association fees, right? So they usually go up. And so what the seller wants is it prorated 100%. What the buyer wants is it prorated 110% to make
To account for an increase.
to account for the increase that no doubt is going to happen. Generally, it's going to be 105%.
That's fair.
And
That's usually fair.
Yeah, but you also want to make sure that there are no senior freezes in terms of income tax. In terms of the taxes on
Well,
the
that
house
is what it is. If
or
you bought
exemptions.
from a senior, I mean,
Well,
that's what it is.
Well, right, but you need to know that in order to, because then what's going to happen is the taxes are going to shoot way up there, and that's not going to cover the spread. And so that's why you want a competent real estate attorney to help you out to make sure that they take care of those issues and make those inquiries. Now we have the attorney review, which we're talking about, and the attorney gets to review the contract.
This is the key to the whole contract, in my opinion.
And you're absolutely right. And that goes hand in hand. We'll talk about the other one, which is the inspection provision, professional inspections. That would cover the radon thing that we talked about too. And so they go hand in hand, and I agree with you. You have 5 business days to request changes except for
Purchase price.
purchase price, exactly. And the changes could be anything in the contract terms, the stuff we were talking about in terms of maybe the taxes, there's an exemption because it's a senior. You might be able to do a modification based upon that. Or maybe you need additional time in order to have your inspection done. I think 5 days is, it's a little shy.
Yeah, I'd like to see it adjust to 10.
Yeah, at least to do that, because a lot of the modifications that we see are extensions of this time or extensions of the mortgage contingency provision that allows, because you have to have it within a certain amount of time pursuant to the contract. If you don't have it and you haven't given notice that you're requesting an extension, then guess what, Dave?
You have to buy it at that rate.
You're stuck
Yeah.
with that.
Typically 45 days on the mortgage contingency unless amended, correct?
Right. And you could agree to pretty much whatever you like. But anyway, so you could ask that certain things be repaired. Maybe after your inspection, there's something wrong with the roof or the hot water heater or the furnace.
There might not be ground fault where there
older.
should be in the kitchens.
Exactly. And so
Things that are now the code.
right. And so the homeowner is going to have to take care of those things, or
I'll take a credit.
your attorney can give you credit for that. That's true. But whenever the homeowner is going to repair it, what we request is that it be done by a licensed, bonded, and insured, either an electrician or plumber, or depending upon whatever problem you have. But now we go according to the inspection provision, and it says if the appliance or if the device, whether or not it's the hot water heater or the furnace, works for the reason for which it was created, then you can't use the inspection provision in order to modify that. However, my feeling is, going back to what you said, Dave, key is the attorney review. Well, okay, and I've had attorneys tell me that, and I tell them, okay, you're right, but guess what? Under the attorney's review provision, we can request modifications for anything except purchase price.
What if you're buying in the winter and you can't test the AC and your inspector can't test the AC? You're not going to know till you get in that property and 6 months later when you turn on the AC whether or not it works.
That's
What do you do
absolutely correct.
there?
Well,
Russian roulette?
you're gonna be out of luck. So you want to have an inspector, and it may be, like you said, that you're not going to be able to test it. But
That's the one thing I think you can't test all
Right.
the time,
yeah,
depending on the season.
and you're going to be, you're going to be out of luck. You're going to have to, and you have the assurance. You could have maybe the request could be that the seller certify that, hey, it was certainly working last time they put it on, and I mean, I don't know what that's going to do for you, other than
Not
maybe
much.
give you a little peace of mind. No,
Not
you're right.
much.
It's not going to do much at all. So now you make these requests, and either they fix them or maybe they give you credit. Now, understand that a lot of times, well, when you're asking for those modifications, it's really what they call in law school, what we learned was a counteroffer. There's an offer, here's the offer, now here's the counteroffer. And so what that does is it kind of nullifies the original offer. So if you make a modification request, the seller can tell you, guess what? You know what? Forget it. I'm going to cancel the contract. But if they do that, you'll get your earnest money back. Now, what they really want to do is sell it, and so
Right. But they might want to look for a buyer who's not so difficult or not demanding certain things because you might be unreasonable.
well, and there's certainly plenty of people that are unreasonable. True enough,
And they
but
might feel so confident in their property that they'll relist it, they'll get another offer real soon, and they'll
Right.
deal with what they determine to be an easier adversary.
that's true. Adversary, not adversary, Dave, a buyer.
Buyer, yeah.
Yeah.
Okay.
But what is what is it? Caveat emptor. Let the buyer beware. Okay.
right.
You always learn. But Dave, you have to understand under the attorney review provision, there doesn't have to be anything wrong. Even the seller, or rather the buyer's attorney, can look at this and say, okay, hey, you know what? Pursuant to the attorney review provision,
Disapproved.
I'm disapproving the contract, period. And there's case law to kind of support that. I believe that you should have, some basis in order to do that. Now, sometimes maybe the buyers are having buyer's remorse.
Yeah, the attorney can always find something anyway.
Right, to kind of get out of that. So that's what you're looking at. And then next one, we talked about the mortgage contingency provision, all those type of things that are necessary. Insurance, flood insurance, you really need to know whether or not you're in a floodplain. And believe me, your lender will let you know. There's going to be no issue with respect to that. If it's a condo, there are other things that you need to have because a condo is an association, so you're going to want to make sure that you get the bylaws of the association.
Those are fun to read.
Those are, I'm not fond of condos for that very reason. If it's my property, I want to be able to do whatever I want with my property. I don't want to have to get permission to somebody because I want to paint something a specific color. Or here's a common wall or any of these things. It's sometimes can get ridiculous. But you want to know what those are, and you want to know what the assessments are, and hey, whether or not there are any special assessments looming in the background there.
Okay, let's talk about a special assessment. Not everybody knows what that means.
Well, everybody knows what assessments are. In other words, hey, that's to take care of the common stuff, the common maintenance, take care of maybe the roof and, just the shoveling and the landscape and all that stuff.
Snow plowing, snow
Snow plowing,
removal.
right.
What's a special assessment?
A special assessment is that maybe the roof on the condo, because since we mentioned that, is so old that it needs to be replaced. And so
And that's not factored in the regular association.
exactly correct. So guess what? We've decided that everybody has to cough up another $1,000 in order to make this happen. And so guess what?
Or a lot more than
Or
that.
more. Well, I'm just, giving an example.
Yeah.
And then guess what you have to do, Dave?
Well, you have to disclose that fact.
Well, if it's
So the
looming,
buyer's aware
if
of
you
it.
know about it, right. But again, those are the things you want to check out. And again, when you have a good real estate lawyer, those are things with respect to not only the contract, but also making modifications will request those specific things.
Yeah, you also have to be careful if you're, say, a contractor who drives a truck and you have a lettering on it. You want to make sure you can park that truck in the complex.
Oh,
and
that's
things of that
a great
nature.
point there, right? Because a lot of times they won't allow you, even in some of the municipalities, even your own home, not necessarily just a condo. But I mean, really, who wants a semi hanging out in their neighbor's driveway? I mean,
Or an RV.
or an RV
Blocking the whole view.
blocking the whole view. That's
Causing a nuisance.
That's right. Well, that's what they say. And then, you go through and you progress. Or rather, the seller's attorney is the one who's going to prepare the documents. We'll talk about title in a minute, but we're going to talk about the deed. The deed is realistically the paper that says, hey, I'm conveying this to you and your wife or to you. And there's a lot of different types of tenancies. If it's just you, okay, so it just goes to you in what they call fee simple. That means lock, stock, and barrel, all yours. Remember that from Property Dave and
I
fee
do.
simple?
Fee simple.
Black acre, green acre, red acre, right?
Long acre.
Yeah,
Yeah, all the acres.
all the acres. And so when you're looking at the deed and you've got that, so I'm conveying it to you. Now the other type of tenancy, another one, is let's say you're buying it with a roommate, or you're not married and you're buying it together. That would be joint tenancy. What that is really is joint tenancy with right of survivorship, and that means that if anything happens to you, everything passes outside of probate to the other joint tenant, and vice versa. And basically, both of you own 1/2 of the undivided whole of that real estate. Now, for married couple, there's tenancy by the entirety, and that provides another level of protections, especially against creditors, because the creditors are not going to be able to attach that if your spouse has creditors, because you own the property as well. So,
Right, the exception is if both spouses owe the debt.
right,
Then they don't get the protection of
right.
tenancy
But if
by the
one or
entirety.
the other, then they're not going to be able to attach the property.
Correct.
So those are things you also want to discuss. Again, if you're married, probably going to be tenants by the entirety, or you might want to put it in trust. Why would you want to put it in trust? Why do you think?
Well, to protect the ownership of it, for one.
Right, the identity.
Yeah.
And
You
but
pay for that. You pay a service fee
you
for
do
that.
pay a service fee, and you can get any trust company, the bank, to do that. But you also want to make sure that if you do that, you don't have the tax bill sent to you, because guess what? Then they're going to know who it belongs to.
Right.
So, again, that's something you got to be smart about too. And so you want to decide if that's something you want to do. Basically, to kind of, it's like hiding an asset, more or less. And then the seller is going to, and according to the real estate contract, at their expense, they're going to order title. Now, what title does and title insurance is to make sure that, hey, listen, that the person who's conveying it to you actually owns it, and so they go back and they do what they call a chain of title, and to make sure there are no judgments or any type of liens or anything on that property, except for the general exceptions, which are real estate taxes and things of that nature, general utility easements and things of that sort. And then what's going to happen too is the seller's going to provide you with a stake survey, and that's going to show you the boundaries of your house and to show you exactly whether or not, sometimes you might have to worry about a fence that's over the line or something like that. You want to make sure that you see that. They're going to have to produce that, and it's going to have to be within 6 months of the closing time. And that's important for you to have as well, and to see the boundaries really of your property. And again, they're going to pay for that. So you're going to have their plat of survey. And then now, Dave, we're getting close to the closing aspect of this, right?
Yeah, we got about 2 minutes till the closing.
Oh, well, then it's going to be a very quick closing, okay, Dave? So at the closing, your lender is going to give you a whole stack of documents. It's going to have a mortgage and a note. The note is the promise to pay the money back. The mortgage is what's going to be secured against the property. You're going to sign all these documents. Your attorney's going to explain them to you. But ultimately, if you don't sign the documents, you don't get the loan. So you're going to sign them. You get them lock, stock, and barrel. The deal is done. And then you know what you do, Dave? You take whomever it is you bought the property with, and you take him or her out to dinner.
And what's the role of the closer that's always hovering around, making sure everything is notarized, multiple copying everything back and forth, making modifications? Who is that person in this transaction?
That person is
important person.
employed by the title company, and they're processing it. They're making sure that they have every document that they need, and it's executed and signed appropriately. And they're the ones that are going to, because all your money is going to go into escrow, and the title company is going to pay it out. They're going to pay off the old mortgage. They're going to pay off any liens or anything else.
If they make a mistake, are they liable to correct it?
The title company is. That's why you have title insurance. But there's also an errors and omissions document that you're going to sign. And basically what it says that if the lender has made a mistake, or the title company has made a mistake like a clerical error, that you agree to cooperate in fixing it. Let's just say that maybe they missed a decimal point, and instead of $102,000, it's $1 million. So those are things that you're going to comply with. They might even sell the servicing of your loan right at the table
I think the bottom line here is that you need an attorney because this is so complex.
before
Jesse,
anything happens.
great having you on the show,
Thanks,
talking about
Dave.
real estate. We'll see you next time on Legal Action. Take care.